Welcome. CPA Planet lessons help you get more points on your CPA exam. These lessons provide clear explanations from the student's perspective, visual learning, and we even try to make it interesting and entertaining. Enjoy the lessons and pass the CPA exam. Okay, we're going to talk about preferential transfers and voidable preferences. The CPA exam will definitely test on preferential transfers and voidable transfers. It's a favorite area of the exam. A preferential transfer is one in which a transfer of cash or other is made to or for the benefit of a creditor or indirectly benefit of the debtor possibly, on account of an antecedent debt of the debtor made within 90 days prior to the filing of the petition, so recently, close in time, made while the debtor was insolvent, results in the creditor receiving more than the creditor would have received under the bankruptcy code. This is not allowed. You cannot favor your favorite plumber. You can't give him more. You can't give your favorite grocer more. You can't give your favorite real estate broker more. We have a system of rules set in place, and you're supposed to follow those rules. And you have to follow those rules in bankruptcy. Now, such preferential transfers can be voided by the trustee. This payment voiding is called a voidable preference. Preferential transfers can be voided if they're made within 1 year of bankruptcy to an insider, such as the corporate officers, directors, partners, relatives, or made to a non-insider within 3 months of bankruptcy, or the creditor receives a large payment that bankruptcy liquidation would not have granted, or oversees priority transfer of assets to creditors. Voiding, setting aside preferential payments purpose. The purpose is to prevent any creditor being preferred over others. We discussed this. The purpose of the setting aside or voiding preferential transfers is to prevent one creditor from receiving an unfairly large repayment relative to other creditors. Intent is not necessarily a requirement to classify transfer as preferential. Maybe you didn't really intend it. Maybe you thought everyone else would get $1 million and your favorite grocer would get only $50,000, but you still can't do it. Example, Mr. Glossop of Glossops, Inc., a retailer, was about to file his bankruptcy petition. However, first he paid in full a 3-year unsecured installment loan owed to Sippings, a creditor who was also a close friend. Glossop's other unsecured creditors will not be paid in full. Therefore, the payment to Sippings can be set aside as a preference. First of all, the payment is a preferential transfer. Number 2, it's a voidable preference. Number 3, it can be set aside. All right. I think you've got the concept here. Not preferences. What are not preferences? Payments for paternity, alimony, maintenance, and child support are not preferences. Again, see our lesson on alimony and child support. It's amazing how many places that hits. Okay, example of not a preference. A regular monthly installment payment will not be set aside as a preference. Current utility bills is not set aside as a preference. Current lease payments do not constitute a preference. PMS perfected within 30 days, not a preference. A PMSI is not a voidable preference if it's perfected within 30 days after the debtor receives possession of the collateral. However, it may be invalid under state law if it's not perfected within 20 days of the debtor's receiving possession. Consumer payments under $600 are not a preference. The trustee may not avoid payments or transfers of property of less than $600, The trustee may not void payments or transfers of property of less than $600 by a debtor whose debts are primarily consumer debts. Domestic support obligations, not a preference. Bona fide payments for domestic support obligations, spousal support, or child support are not voidable preferences. Again, see our alimony and child support lesson. Okay, contemporaneous exchange for value is not a preference. This is fairly common sense. Example, Jeeves, a retailer, was about to file for bankruptcy. A few days before this, he received 10 boxes of inventory supplies from Bertie, his supplier. Jeeves paid for the goods in full on their arrival. There's not a preference here because it's a standard business transaction, contemporaneous exchange for value. Example, debtor is a hot dog stand owner, and purchased a case of soda to use as retail, paying in cash at the time of delivery. The trustee cannot set this aside. It's a standard payment for value. Debtor is a hamburger stand owner who purchased 1,000 beef patties to be delivered on June 15th. The seller, creditor, took a PMSI in the inventory. If the secured seller, creditor, perfects its secured interest within 20 days, remember that, 20 days after the debtor took possession, this security interest is not a preference. The trustee cannot set it aside. So you're seeing the pattern here, and you're seeing the logic, and you're seeing the pattern, and the rules, a couple rules like the 20 days to perfect a PMSI. All right, insolvency is presumed during the 90 days preceding bankruptcy. If you declare bankruptcy, the 3 months prior to that, you are assumed insolvent during that period. Payments during that period can be set aside. They can be classified as preferential, and they can be voidable, and they can be set aside. A fully secured concept note. A preference exists only if the creditor receives more than he or she would receive in a bankruptcy decision. Therefore, payment to a fully secured creditor is not a preference because the creditor would have received the collateral and been paid in full anyway. Okay, voiding preferential transfers, not voidable. Accounts payable made within the ordinary course of business. We talked about this. So some of this is repetitive. We're repeating some stuff here just so you understand it. If the debtor is an individual, payment of up to $600 in consumer debt within 90 days preceding the filing of the petition. We covered that already. For primarily non-consumer, any transfer less than $5,850. Asset transfers for new values such as materials acquired for cash or borrowed money received in exchange for security interest. Again, we covered this already. Gifts that are not on account of a debt. A gift is not a preferential transfer. You just got to make sure it's a gift, and that's fine. Transfers for domestic support obligations. For example, a tennis ball app company orders a truckload of tennis balls. They pay for it upon arrival. 40 days later, they declare bankruptcy. This debt, not debt, but this payment that they made is not voidable because it was an even exchange and was not payment for a prior debt. It was a contemporaneous exchange. It was a normal business transaction. Intent to delay or defraud creditors. A transfer is voidable if there's proof that a property transfer within 2 years prior to filing was with intent to delay or defraud creditors. So that you got a 2-year window there for a property transfer, potentially. You can void if it's less than equivalent consideration for a transfer if a trustee may void a transfer of debt if the debtor received less than reasonably equivalent consideration. If the debtor was insolvent or made insolvent by the transfer, was operating a business with an unreasonably small capital, or was expected to incur debts that he or she could not repay. Exceptions, transfers that cannot be set aside by trustees. The payment of a debt incurred in the ordinary course of business or financial affairs of the debtor. Example, debtor pays his cell phone bill upon receipt. Debtor pays his car payment upon receipt. These are ordinary course of living, business, cannot be set aside. They're valid payments, even if you're in bankruptcy. A non-consumer debtor's payment of up to $5,850 is not a preference that cannot be set aside. We covered this already. All right, bringing transferred property back into the estate. So we've covered the trustee can void a transfer. A preferential transfer, trustee can void it. So what happens next? Bring the property back into the estate. These set-asides of transfers by the debtor are called voidable preferences. We know that. Trustees can set aside transfers due to the usual contract offenses such as duress, mistake, undue influence, failure of consideration, debtor incapacity, etc. Okay. Example, if the debtor was incapacitated at the time of transfer and is now in bankruptcy, the trustee has the right to deaffirm the transfer due to the incapacity. If the debtor entered into a fraudulent transaction and is now in bankruptcy, the trustee has the right to disaffirm the transfer due to the fraudulent transaction. So that's very common sense. Whether or not you're in bankruptcy, you can disavow or set aside a transfer that's fraudulent or when you're incapacitated. See also the contracts in capacity lesson. That's I cover that in detail there. Example, Tom Wooster transfers a boat, which is non-exempt property, to his daughter. He retains possession and use. He also buys a $600,000 life insurance annuity contract. 3 days later, he files for bankruptcy. Wooster already has $4 million of life insurance. So a lot of facts here. Okay, the transfer of the boat and the purchase of the $600,000 policy can both be set aside and become property subject to the bankruptcy proceedings. Transfers made after bankruptcy. Trustee can set aside transfers of property of the estate after the debtor becomes subject to the bankruptcy proceeding, except those made with permission of the trustee of the court. So, for example, you go into bankruptcy, you sell your stereo to somebody for $5, and then you expect to get the money back later somehow. That can be set aside. It's not in the ordinary course of business.